just for the presiding judge, Carol will show up the time that is remaining. So 10 minutes remaining, 5 minutes remaining, 3, 2, 1, 0. So that we try to keep to the time, even though, you know, there may be some small disruptions. The session is long already. So we really try to keep to the 15 minutes also for equality and fairness to each of the participants. We also ask, please.
It will still be okay if I don't catch her her pointing to me the time for her to speak up and say the time is up.
Okay, so just at the last one, Carol, when the time is up.
Yeah.
And then, I mean, obviously the participant can complete the sentence, you know, it's like at least maybe 20 seconds or so, but not more and more minutes. They always try their luck to continue for a long time. And then just imploring the judges to ask questions, you know, so that the students are put on the spot and we see their responses to questions. And in fairness, we try to, you know, make the point that the judges should try to ask each of the participants. Sometimes, especially, you know, the first one starts off and it's a bit quiet, and then we get a lot of questions on the end. So the last one gets all the questions, not the first one. So just to keep that in mind, I think Commissioner King knows the story. She's been part of it.
Excuse me, Franz. Sayad, Professor Musalo and Professor Sambacham joined us, but I don't know if they know how the translation works. So I just explained them in French how it was. Voilà, Professeur Musalo, Professeur Sambacham. Donc, merci de rejoindre la séance de briefing avant la finale. Donc, vous avez la possibilité de suivre en français en cliquant sur l'onglet en bas interprétation et vous choisissez français pour pouvoir avoir la traduction en français. Donc, professeur Sambacham de l'Université Cheikh Anta Diop de Dakar et professeur Moussalo qui est le coordonnateur de l'Université virtuelle du Sénégal. Merci. Thank you, sir. Thank you, France.
Thank you very much, and most welcome to our colleagues, our esteemed colleagues who are very, very welcome. We also introduce to you the Vice Chancellor of the University of Pretoria, Professor Coupe, Professor Thiam, and Professor Lo. You are most welcome, and thank you so much for joining us. So the sequence, as you know, will be that Professor, that Sayat will be the moderator, and he will call on you. We'll start off with Professor Coupe.
Okay, thank you very much, everyone. We are, 1 minute past, the official starting time. So without further ado, I would like, to invite our Vice Chancellor and Principal, Prof. Coupe, to give us some few opening remarks, and he will be followed by Professor Moussalo of the Université virtuelle du Sénégal. And Prof. Samba Thiam, who is the director of the Institute of Human Rights and Peace, Cheikh Anta Diop for Dakar. Professor Coupe, the floor is yours.
Thank you very much. Good afternoon to everybody on this momentous occasion. Honored guests, Professor Jean-Louis Correa, Dean, Pole Science, Economic, Juridique, and the Administration, Université virtuelle du Sénégal. Professor Moussa Lo, Coordinator, Université virtuelle du Sénégal. Professor Ibrahima Tiwab, Rector, Université Cheikh Anta Diop de Dakar. Honored final round judges, African Court on Human and People's Rights, Judge Stella Anacom, two commissioners of the African Commission on Human and People's Rights, Commissioner Solomon Deso, Chairperson of the Commission, and Commissioner Jamesina King. Judge from the highest court in Senegal and a renowned academic, Professor Lawrence Bogog Lassen, Professor of Law, Sorbonne Law School, Université Paris 1. Welcome to the final round of the 29th African Human Rights Moot Competition. The compelling and highly relevant issues of enormous contemporary concern in Africa and worldwide that the finalists will be arguing on Zoom today include cyber surveillance, revenge porn on the internet, and corruption. This year, the co-hosts with the University of Pretoria Center for Human Rights are two Dakar-based universities, and we're very, very proud of this. Université virtuelle du Sénégal and Université Cheikh Anta Diop de Dakar, which I visited in the past. It is the first time that they are hosting the finals, and it would have been wonderful to be with you in person. However, due to the COVID-19 pandemic, as we know, the entire competition had to be held virtually this year. Even so, the rounds leading to the finals today have been riveting, with top law students tackling hypothetical human rights cases relating to artificial intelligence, data protection, cybersecurity, social media regulation, freedom of speech, and corruption. In terms of relevance, these are top of the list. Students from 29 English-speaking and 7 French-speaking universities from across the African continent competed in this year's edition, arguing as if they were before the African Court on Human and People's Rights. The competition continuously prepares new generations of lawyers to argue cases before this court. An exciting development this year is that the moot competition has extended beyond our academic institutions, with 2 teams of prison inmates from Uganda and Kenya taking part in this year's competition. Another first is that this year, 4 finalist teams will be combined into 2 teams. This requires students from different universities, different backgrounds, different languages, and different legal traditions to work together. We welcome and congratulate the finalists who are from the following universities: Makerere University, Uganda; Université, Félix, Houphouët-Boigny de Cocody, Ivory Coast; University of Ghana, Legon; University of Pretoria, South Africa. 1992 was the first year of the African Moot Competition, and for 29 years, it has been co-hosted by the Center for Human Rights, together with another law faculty from countries across the continent. The African Moot has taken place in 17 different African countries. Over the years, close to 170 different universities from 50 African countries have participated. It's phenomenal to think that this is the largest gathering of students, academics, and judges around the theme of human rights in Africa. Our huge gratitude goes to the competition organizers from the Center for Human Rights, University of Pretoria, Mr. Yusuf Sayad and Professor Franz Filion. As always, scores are awarded according to the following criteria: knowledge of facts, articulation and correct analysis of issues, familiarity with international law with preference for African authorities, persuasiveness, ingenuity, organization, ability to respond to questions. In 2021, the African Moot will celebrate its 30th anniversary, and the co-host is Stellenbosch University in South Africa, whose law faculty will be commemorating its centenary, 100 years of existence. Hopefully, with the encouraging developments on the COVID vaccination front, we can meet again in person. Although Zoom has done us proud this year and the hybrid approach considerably saves us, our deep gratitude to all who have made this possible. May the final round begin. All the best. Thank you.
Thank you, Prof. Coupe. We're very much grateful. And now I will ask Prof. Moussalo, coordinator of the Université Virtuelle du Sénégal, to address in very few words, the gathering. Thank you.
Merci, bonjour. Monsieur le Président de la Cour suprême du Sénégal, Monsieur le recteur de l'Université de Pretoria, Monsieur le représentant du recteur de l'Université Cheikh Anta Diop de Dakar, Mesdames et Messieurs les membres du jury, Monsieur le directeur du Centre for Human Rights de Pretoria, Mesdames et Messieurs les membres du comité d'organisation, chers collègues, chers étudiants, Mesdames et Messieurs en vos titres et qualités, c'est avec un réel plaisir que je prends la parole ce matin au nom de l'Université virtuelle du Sénégal à l'occasion de la finale de la 29e édition du concours africain de procès simulé des droits de l'homme. Je voudrais, à l'entame de mes propos, féliciter les organisateurs qui ont su, avec agilité, s'adapter au contexte lié à la pandémie de la COVID-19 et nous permettre d'organiser cette édition du concours africain de procès simulé. En portant le choix sur un thème axé sur le numérique, personne ne se doutait que c'est le numérique qui allait permettre la tenue de cet événement. En tant qu'université numérique, l'université virtuelle du Sénégal a été honorée de participer à l'organisation de ce concours portant sur le numérique et les droits de l'homme et en utilisant le numérique pour pouvoir arriver à l'organiser correctement. Je me dis qu'il n'y a pas de hasard. Et c'est le lieu aussi pour moi de remercier le centre for Human Rights de Pretoria et tous ceux qui organisent ce concours, qui nous ont accordé la confiance avec l'UCAD pour abriter le concours cette année au Sénégal. Et malheureusement, cette pandémie a fait que le Sénégal ne pourra pas vous accueillir à Dakar. On aurait aimé vous retrouver tous à Dakar et vous faire profiter de la teranga sénégalaise. Mais malheureusement, je pense que la pandémie est passée par là. J'espère que ça va être pour une prochaine fois. Mais dans tous les cas, en tout cas, ce qui est important aujourd'hui, je pense, c'est qu'on puisse avoir les moyens d'organiser cette édition jusqu'à arriver à cette finale qui se tient ce matin. Et c'est le lieu aussi pour moi de féliciter les étudiants, l'équipe de l'Université virtuelle du Sénégal. Nos étudiants se sont arrêtés aux portes de la demi-finale, de la finale, je crois qu'ils sont allés jusqu'en demi-finale. Et leur dire que nous sommes fiers d'eux et de tout ce qu'ils ont fait en tout cas pour représenter honorablement leur institution. Je ne saurais terminer sans remercier encore les membres du jury qui ont bien voulu nous accorder de leur temps pour participer à cette finale. Mais surtout remercier vraiment France et toute l'équipe de Pretoria qui, depuis le début, nous ont associés à cet événement. En tant que jeune institution qui a à peine 7 ans, nous avons été honorés d'avoir en tout cas été au centre de cette organisation-là. Et nous espérons encore pour longtemps, en tout cas, être vraiment un acteur incontournable de cet événement-là, parce que ça nous tient à cœur et nous souhaitons participer à notre façon, en tout cas, au développement de ce concours qui permet non seulement de rassembler les jeunes, mais surtout de former une élite africaine dans le droit. Je pense que c'est extrêmement important. Voilà, donc je souhaite bonne chance aux finalistes et que le meilleur gagne. Je vous remercie pour votre aimable attention. Merci.
Merci beaucoup au professeur Lo. Now I'd like to invite Professor Sambatiam to address the gathering. Thank you.
Oui, je suis là. Je voudrais vous remercier de m'avoir donné la parole. Heureusement que nous pouvons nous exprimer en français, puisque au tout début, quand j'entendais l'anglais, je ne parle pas très bien cette langue. Je m'en veux d'ailleurs pour ça. Je vous remercie de me permettre donc de vous suivre. Saluer chaleureusement tout le monde, remercier les organisateurs. J'ai voulu d'ailleurs reprendre le discours du professeur Lo, puisqu'il parlait pour nous. Je me retrouvais parfaitement dans son discours. Je continue quand même en remerciant encore une fois l'Université de Pretoria, l'université virtuelle qui fonctionne sous l'autorité du professeur Lo, Jean-Louis Correa et mon collègue Abdou Khadr Diop. Je voudrais qu'il me soit permis vraiment de remercier Abdou Khadr qui m'a suivi pas à pas, qui n'a pas cessé de m'informer à chaque fois de l'évolution de ce processus. et au nom de l'Université Cheikh Anta Diop, du recteur de l'Université, le professeur Mbaye, au nom de l'Institut des droits de l'homme et de la paix que je dirige, je félicite encore une fois les organisateurs, les finalistes. Qui dit concours dit meilleur à l'occasion de l'organisation, dit notamment talent, dit apte à impressionner, à convaincre et surtout à enfermer la personne qui vous écoute, qui vous lit dans une vérité qui s'impose. Je pense que je parle sous le contrôle du premier président de la Cour suprême du Sénégal, que je salue au passage, et ses mirobolants. C'est fabuleux si cet effort s'appuie sur les droits de l'homme, les droits humains, n'est-ce pas, la promotion, la protection et la défense des droits de l'homme justifie notre mobilisation, notre solidarité, notre engagement. J'en profite pour dire bonne fin d'année à tout le monde, espérant que la COVID-19 va nous libérer totalement sous peu et que nous allons retrouver l'année 2021 dans un bonheur immense. Merci encore une fois.
Merci beaucoup, cher professeur Sambatiam. Now I would like we're going to quickly move to introducing the judges, and I would like, to call my colleague, Abdulhadre Diop, who's been my partner in crime, as it were, because he was the organizer on the other side with our Senegalese partner. He's going to do the introduction of judges. Abdulhadre, please take the mic.
Merci Sayad, mon partenaire de crime, comme tu l'as dit. Merci beaucoup. Alors, professeur Moussalo, coordonnateur de l'Université virtuelle du Sénégal, professeur Tawana Koupé, vice-chancellor de l'Université de Pretoria, professeur Sambatiam, directeur de l'Institut des droits de l'homme et de la paix de l'Université Cheikh Anta Diop de Dakar, professeur France Villowen, directeur du Center for Human Rights, chers juges, membres du jury, chers étudiants, chers participants. C'est un plaisir pour moi de pouvoir introduire nos différents juges qui siègent aujourd'hui dans cette finale assez particulière du concours africain de procès simulé. Je pense que c'est la première fois qu'on a une finale en ligne. Voilà, toutes les autres années, on s'est retrouvés en présentiel quelque part. Et c'est la première fois, donc en raison de Covid-19, comme l'a rappelé tout à l'heure le professeur Sambatiam. Et nous pensons que nous aurons l'occasion très prochainement de vous accueillir à Dakar pour une compétition en présentiel, pour profiter, comme le disait le professeur Moussalo, de la teranga sénégalaise. J'en profite pour présenter les excuses du professeur Jean-Louis Correa, qui est le doyen donc, de notre pôle sciences juridiques, économiques et de l'administration, qui devait introduire les juges, mais qui a un conflit d'agenda, donc il a une soutenance de thèse en même temps, et c'était un peu compliqué pour lui, et il m'a demandé de le représenter. Donc je vais sans plus tarder présenter les différents juges. 4 juges aujourd'hui, et la présidente de aujourd'hui, c'est commissaire Diamasina King, qui est donc actuellement commissaire à la Commission africaine des droits de l'homme et des peuples, et qui a plusieurs casquettes, qui est aussi présidente du groupe de travail sur les droits économiques, sociaux et culturels en Afrique, qui est également présidente du comité des résolutions dans la dite commission, et en même temps également membre du groupe de travail sur les industries extractives, l'environnement et les violations des droits de l'homme. En même temps, plusieurs casquettes toujours, commissaire King, membre du groupe de travail sur les communautés et populations autochtones. Donc, la commissaire Jamasina King va être la présidente donc, de la Cour durant cette finale. Je m'en vais par la suite présenter l'honorable juge Stella Anoukam. Honorable juge Stella Anoukam, qui est de nationalité nigériane et qui est juge à la Cour africaine des droits de l'homme et des peuples. Donc, Madame Anoukam a été élue en juillet 2018 pour un mandat de 6 ans. Juge Anoukam possède plus de 32 ans d'expérience professionnelle avec une compétence avérée et exceptionnelle en matière de protection internationale des droits de l'homme. Donc, juge Anoukam, soyez aussi la bienvenue. Professeur Laurence Bourgogne-Larsen, qui a récemment publié un ouvrage remarquable sur les trois cours régionales que j'ai eu beaucoup de plaisir à lire et à consulter, et professeur de droit à la faculté de droit de la Sorbonne, Paris 1. Elle est membre de l'Institut de recherche en droit international et européen de la Sorbonne et directrice du groupe d'études sur le droit international et le droit latino-américain de la Sorbonne, de la dite université. Elle a été de 2012 à 2019 juge à la Cour constitutionnelle d'Andorre et en a assuré la présidence pendant 2 ans, de 2014 à 2016. Professeur Larsen, c'est toujours un plaisir de vous retrouver. Nous partageons encore une fois le monde académique, donc la bienvenue dans cette finale. Enfin, nous avons le docteur Solomon Derso, qui est président de la Commission africaine des droits de l'homme et des peuples, commission de Banjul, et qui est également directeur fondateur d'Amani Africa. Amani Africa, Media and Research Service, est un groupe de réflexion panafricain de recherche sur les politiques basées à, donc qui est basé à Addis Abeba. Docteur Derso est également président adjoint, professeur adjoint au collège universitaire d'Addis Abeba pour les études de droit et de gouvernance. Honorable Derso, soyez le bienvenu dans ce jury. Donc voilà notre jury. Il y avait une 5e personne, le juge Omar Gaye de la Cour suprême du Sénégal, mais qui s'est excusé à la dernière minute parce qu'il ne se sentait pas bien en raison d'une maladie. Donc il tenait également, à travers ma voix, présenter ses excuses pour ne pas pouvoir rejoindre le panel des juges. Cher Sayat, voilà donc les différents juges qui vont aujourd'hui siéger dans cette finale du concours africain de procès simulé, édition 2020. Merci beaucoup.
Oh, thank you, Sheikh Abdulhad. Now we're going to what we all have been, waiting for. Now it's after the preliminaries and the introduction. Now it's the time to begin the final. Quickly, just to say so that the proceedings run smoothly. Most of you have used this platform. We're going to request people who won't be taking part in these proceedings to please mute your mic and preferably also deactivate your videos. Now the platform is going to be reserved for the oralists and the judges. Thank you very much. I'm going to quickly ask the applicant team, can you confirm if you are in court?
Yes, you can.
Defendant team, can you confirm if you are in court?
I can confirm that I am present and ready to present.
Thank you very much. I'm going to hand over the proceedings, to the chairperson to the chair of this of the bench, who's Commissioner King, to take it from there. Commissioner King, now the court is in your hands. All the teams are present. Now we can begin. Thank you very much.
Thank you very much. Thank you. Good morning, good afternoon, everyone. And allow me to stand on existing protocols and to move to business. Honorable judges present, we would now ask the applicants team to begin. And before they start, I just want each panelist to know, or each oralist to know, that they have 15 minutes. And we have, we'll indicate to you what time you have left, but each person has 15 minutes, but the first person will have 12 minutes. So can the applicant team begin? Thank you.
Judge President, Your Excellencies, my name is Thuweba Moses, and I will be representing the applicants, Basanabat Act 2 and Liberty 2.0, along with my co-agents, Martha Nasanga, Denhendri Pillay, and off-counsel, Gertrude Nabudua. I'll be speaking first for 12 minutes on jurisdiction and admissibility. Ms. Nasanga will speak for 15 minutes on Pres 1 and 4, and Ms. Pillay will speak for a further 15 minutes on Pres 2 and 3. We reserve 3 minutes for rebuttal. Before I proceed, would the court benefit from a summary of the facts? Apologies, Your Excellency, but your mic seems to be muted.
Yes, you're Miss Moses, right?
Yes, Your Excellency.
I just want you to know that any of us as judges will take the floor at any time to ask you questions. So please be prepared for that. Thank you.
Yes.
We'll see.
Your Excellencies, would you benefit from a summary of the facts?
Yes, please proceed.
Denamistan is a West African state that is currently experiencing high ethnic tension. This is due to the presence of the terrorist group Al-Shabaab. There are 4 issues in contention before the courts today. First, in relation to Article 8 of Denamistan's Electronic Communications Code, which allows the state to intercept external communications. Second, in relation to the forced closure of Basanabat Act 2's pornography sites, as well as their convictions on defamation and terrorism. Third, in relation to the arrest and imprisonment of the prominent Douala activist, Thea Maka, for a video in which she was simply criticizing the president. And fourth, in relation to Denamistan's failure to prosecute the Minister of Education for his acts of corruption. I'll now proceed to address the courts on jurisdiction. We submit that the court has complete jurisdiction over all the matters before it. These specific issues in contention relates to the court's temporal, personal, and material jurisdiction. Under temporal jurisdiction, the respondents have argued that the court is lacking in temporal jurisdiction as Denamistan promulgated Article 8 of the Electronic Communications Code before the state made their declaration under Article 34.6 of the protocol. However, the respondents' arguments are flawed and must not find any standing within this court, as according to the 2011 beneficiaries of late Norbert Zongo versus Burkina Faso, the African court held in paragraph 62 that the court's temporal jurisdiction arises not when legislation has been promulgated, but when the violation has occurred after the declaration. According to paragraph 3 of the facts, Dynamicstein made their declaration under Article 34.6 on the 12th of April 2018. And according to paragraph 7 of the facts, the Minister of Education issued the warrant for the interception of communications on the 4th of May 2018. Consequently, it is clear that there is a 1-month period between the declaration and the violation, and thus it is clear that the court is indeed vested with temporal jurisdiction. I'll now proceed to personal jurisdiction. The issue in personal jurisdiction arises as Bustanabat Act 2 is a limited liability company, according to paragraph 11 of the facts. The respondents have argued that seeing as Bustanabat Act 2 is a company, that the court is lacking in personal jurisdiction, and they have made reference to the 2018 Jean-Claude Roger Gomet versus Côte d'Ivoire, where the court made clear in paragraph 47 that the court concerns itself with human and people's rights. It is on this basis that the court is vested with personal jurisdiction today. In Jean-Claude, the court distinguished between Agriland and Jean-Claude, even though they had brought a violation in tandem. Notably, the court affirmed that the identities were the same, despite Jean-Claude being a natural person and Agriland a company. The court reached this conclusion by piercing the corporate veil. Your Excellencies, we submit that this is the appropriate cause of action, given that the case before the court today concerns Bustanabat Act 2 as a media outlet. Bustanabat Act 2's rights as a media outlet are of significance, as its rights are inextricably linked. Its right to freedom of expression, rather, is inextricably linked to the right to freedom of expression of the users and workers of the site. According to PHPHMC van Kempen, in Human Rights and Criminal Justice Applied to Legal Persons, the media is indispensable to the individual's right to retrieve information. And thus, seeing as we are dealing with a media outlet and the violation of a fundamental right, as per the 2019, Dexter All Limited versus Côte d'Ivoire, which was held in the ECOWAS court in paragraph 72. The court should follow the Jean-Claude case and similarly pierce the corporate veil to establish the identity of the party before it. On this score, the court should find that the identity of the party before it is that of the users and workers of the site, these being natural persons. And consequently, seeing as the court is dealing with violations brought by natural persons, it is indeed vested with personal jurisdiction according to Article 5.3 of the African Court Protocol. I'll now proceed to address the court on material jurisdiction. The issue in material jurisdiction arises in prayer 4 and whether the AU Anti-Corruption Convention is a human rights instrument. We submit that the convention, I refer the court to the 2016 APDH versus Côte d'Ivoire, where the African Commission held in paragraph 47 that a human rights instrument must contain an obligation on states to promote a right within the Charter. We submit that the convention promotes the rights to development through the promotion of public participation in Article 7.3 and 20 of the convention. Consequently, it is a human rights instrument and the court is vested with material jurisdiction. I'll now proceed to address the court on admissibility. We submit that all requirements... Yes, Your Excellency.
Je trouve que vous inférez un peu trop rapidement la compétence matérielle de la Cour africaine. pouvez-vous être plus précise sur la jurisprudence de la Cour africaine dans l'affaire APDH contre Côte d'Ivoire et préciser très clairement les deux critères que la Cour a utilisés pour expliquer l'amplitude de sa compétence matérielle à d'autres instruments qui n'ont pas a priori un lien avec les droits de l'homme. Je trouve que vous avez été un peu trop rapide sur ce point. Merci d'avance.
Your Excellency, then, to elucidate the court further on the APDH case, the African Commission held in paragraph 57 that a human rights instrument must either contain an express enunciation of subjective rights or obligate states for the promotion of a right within the Charter. According to the African Commission in the APDH case, they found that the Charter of Democracy was a human rights instrument as it contained an indirect obligation on states to promote Article 15 of the African Charter. Similarly, the AU Anti-Corruption Convention contains an indirect obligation on states to promote the right to development. And thus it is on this basis that the court should find that it is vested with material jurisdiction. With regards to admissibility, we submit that all the requirements under Article 56 of the Charter have been met. Specifically, local remedies have been exhausted in Pres 2 and 3, and I refer the court to page 1 of our memorials for further ventilation of these arguments. However, with regards to Pres 4, the respondents have contested the admissibility of the communication, as they have alleged that the applicants should have pursued private prosecution of the minister. However, paragraph 3 of the facts makes it clear that private prosecution is only available. Yes, Your Excellency. I see that there might have been a technical issue, so I will proceed with my argument. With regards to Prayer 4, the respondents have submitted that the applicants should have pursued private prosecution. However, paragraph 3 of the facts makes it clear that private prosecution is only available where the state has refused to prosecute. The state has not refused to do so, but rather unduly prolonged local remedies. This is as per paragraph 13 of the facts, which makes it clear that the MPA has been seized with the matter for 8 months. They have yet to institute proceedings. There are no factual reasons for the MPA's delay in prosecuting the minister. And further, in the 2007 Article 19 versus Eritrea, the African Commission held in paragraph 72 that whenever there is a crime that can be investigated and prosecuted by the state has the obligation to move the criminal process forward to its conclusion. Consequently, seeing as the state has failed to do this—
Excuse me, Ms. Moses, in relation to exhaustion of domestic remedies for the Minister of Education, what about private prosecution? Couldn't it have been instituted against the Minister of Education? Thank you.
Your Excellency, I see that my time has elapsed. So would the court allow me a 30-second extension to answer your question and conclude?
You have 1 more minute, so just use that minute.
Thank you, Your Excellency. To answer your question, private prosecution was not available to the applicants, as paragraph 13 of the paragraph 3 of the facts makes it clear that private prosecution is only available where the state has refused to prosecute. The state has not refused to prosecute the minister, but rather unduly prolonged local remedies. This is as per paragraph 13 of the facts, which makes it clear that the MPA has seized the matter, but has yet to institute proceedings. Furthermore, in the Article 19 versus Eritrea, in the African Commission held in paragraph 72, that in such cases where the state can prosecute and investigate, that one cannot demand that the complainants assume the task of prosecution.
Your time is up.
In conclusion, I'll now take my leave of the court and hand over to my co-agent, Ms. Nasanga.
Thank you. Is Ms. Nasanga there, please?
Yes, Your Excellency. I beg your pardon. I was having a struggle with the video feed. Judge President, Your Excellency, my name is Masa Nasanga, the second agent for the applicants Bustanabad Act 2 and Liberty 2.0. And I will be addressing this honorable court on issues 1 and 4 using the approximate time of 15 minutes of this honorable court's time, of course. Starting therefore with prayer 1, it is our contention with regard to the actions undertaken by Donamistan concerning the execution of Article 8 of the Electronic Communications Code of Donamistan, that the state's measures have disproportionately interfered with the rights of the people's rights, of the people to privacy and to free expression or freedom of expression. The people derive and make claim to these rights on the basis of Article 9 of the African Charter, and that is with regard to the right to free expression, but also to Article 19 of the ICCPR, that is the International Covenant on Civil and Political Rights, concerning the same right, and Article 17 concerning the right to privacy within the same convention. We argue that the state's execution of the interception, or otherwise, its surveillance of the people, of the communications of the people received externally, was disproportionate to privacy and free expression because it was lacking in sufficient safeguards. The lack of these sufficient safeguards, therefore, would defeat, Your Excellencies, even a legitimate or otherwise necessary purpose for the execution of these measures, Your Excellencies. Because while a measure may indeed be legitimate, such as national security and the intention to protect the state from external attack and terrorism may indeed be legitimate, the same must be pursued in view of safeguards intended to ensure proportionality. This has been pointed out and discussed in the case of Big Brother Watch versus the United Kingdom before the European Court of Human Rights. That being the case, we argue that the state of Donamistan should have included safeguards to address the Minister of Communications' capacity to issue warrants without reproof to any other authority, but also concerning, Your Excellencies, the filtration of that particularly received information, that is to say, the use of automated intelligence or automated data processing systems. The lack of that filtration is one of the safeguards that they needed to have addressed. The state of Donamistan needed to have made provisions for that filtration of the data, considering the fact that automated intelligence or automated data protection systems are known and prone to bias, but also should have provided for prior authorization or otherwise subsequent review of the warrants issued by the Minister of Education, the Minister of Communications. These undertakings instead were ignored by the government of Donamistan. To that consequence, we argue that their undertakings were disproportionately executed and therefore unacceptable violations of their people's rights. Proceeding, Your Excellencies, to our particular concern with regard to the purpose of the intersection. This purpose has been stated and pointed out by the respondents, but also necessarily agreed upon to have been the combating of terrorism. And while that is acceptable, the case of Szabo and Vizi versus Hungary specifically points out and advises that even in circumstances of imminent terrorist threats, there is a need to have subsequent review of intercepted communications or intercepted data in consequence of the fact that in those circumstances, perhaps prior authorization might then not be feasible. So you see, Your Excellencies, even if it were to be argued that in response to an imminent threat, the state of Donamistan could not possibly resort to prior authorization, it is and indeed was still necessary for them to undertake subsequent review. This is also not provided for under the Electronic Communications Code regarding the information intercepted via Article 8. Due to these lacks...
Excusez-moi, Legon.
Yes.
Si je peux permettre. Vous avez invoqué une jurisprudence de la Cour européenne des droits de l'homme, mais en quoi l'État serait contraint de respecter une jurisprudence étrangère? Merci d'avance pour votre réponse.
Thank you, Your Excellency. Foreign case law, while not binding before this honorable court, Your Excellency, is of persuasive value as a matter of general practice in international law, where a court may refer to the decisions of another court with regard to an issue that has been sufficiently addressed by said court. Therefore, where that particular court finds that case to be persuasive, to be acceptable, Your Excellency, they may allow themselves to refer to it and indeed decide likewise. This is what we move the court of this honorable court to do.
Counsel, can you convince the bench or address the bench on why you think, in the face of the threat of terrorism, the steps taken by the defendant state are disproportionate?
Your Excellency, in brief, we believe the steps taken by the respondents are disproportionate because they do not provide for the filtration of the data collected, the sufficient filtration of the data collected by automated data processing systems, but also that they do not provide for the prior authorization to the Minister of Communications of regarding the issuing of his warrants. But that notwithstanding, why this honorable court to decide that prior authorization was perhaps not feasible in circumstances of imminent threats, Your Excellency, we then argue they are still disproportionate because they do not provide for subsequent review. In other words, their safeguards do not allow for a proportionate interference with privacy, Your Excellency. Thank you, Your Excellency.
You may proceed. Thank you.
Having addressed these issues, I proceeding therefore to issue 4, or otherwise D, which concerns the Minister of Education and the failure of the respondent state to prosecute this man for his acts and undertakings of corruption in violation of the African Union Anti-Corruption Convention, but also in violation of various provisions of this honorable court's charter, that is the African Charter of Human and People's Rights. The failure of the state of Donamistan to prosecute the Minister of Education is indeed a violation of, firstly, the right to development, but secondly, also a violation of the anti-corruption Convention of the African Union as a whole's provision for the need for its signatory states to prosecute or to punish, otherwise, to punish the undertaking of acts of corruption by officials in their states, Your Excellency.
Counsel, if I may come here, can you please elaborate the connection between the Convention against corruption and the right to development?
Thank you.
I couldn't get how you have established a direct link between these in order to make a case that failure to prosecute a corruption case amounts to a violation of the right to development.
Thank you, Your Excellency. With regard to Your Excellency's question, firstly, Your Excellency, my co-agent, Ms. Moses, discussed the link between the right to development and indeed corruption. The idea and our argument indeed being that corruption does indeed impede the participation and involvement of the people within a state in the affairs and general exercise of their powers and positions. That is to say that it blocks, Your Excellency, the general capacity of, in simpler terms, of this state to develop. I will give Your Excellency an example concerning this very Minister of Education's undertakings. Your Excellency, this Minister of Education diverted money from a fund intended to build schools, Your Excellency, to construct schools. These schools, until today, are yet to be seen in Donamistan. This cannot possibly otherwise but be a violation of the right to development. The Minister of Education's undertakings, Your Excellency, therefore having addressed this question, the Minister of the Minister of Education's undertakings become also a violation of the Anti-Corruption Convention of the African Union, and particularly of Article 4.1 and various provisions beneath, that is B, C, and a bit of F. But also violate those particular provisions insofar as they require signatory states such as Donamistan to undertake, Your Excellencies, punishment of these offenses of corruption. The offenses are defined clearly in the African Union.
Ms. Nasanga?
Yes, Your Excellency.
Kindly round up, you have 1 minute.
Yes, Your Excellency. In summary, Your Excellency, therefore, it is our argument in whole that the Minister of Education's actions did indeed amount to acts of corruption according to the Anti-Corruption Convention, and therefore violated the same and should have been prosecuted by the state of Donamistan as it is required to do under the same convention, but also in pursuance of the right to development under Article 22 that it is required to protect by the African Charter. Having concluded, Your Excellency, I'd then love to cede the floor to my co-agent, Ms. Pillay, to address this honorable court on issues, Your Excellency, 3 and 2. Thank you.
Thank you very much, Ms. Nasanga. Ms. Pillay, you have the floor.
Judge President, Your Excellencies, my name is Dinendri Pillay, agent on behalf of the applicants, Liberty 2.0 and Bestanabad Actu. I'll be taking approximately 15 minutes of the court's time to address the merits of prayers 2 and 3. In turning the court's attention to prayer 2, the conviction of Bestanabad Actu and the closure of its website is a violation of Article 9 of the African Charter, as well as 19 of the ICCPR. 2 arguments are made in this regard. First, concerning the dissemination of immoral content, and second, relating to charges on defamation and terrorism. Paragraph 11 of the facts indicates that Bestanabad Actu was charged for disseminating imagery contrary to morality, pursuant to Article 112 of their Criminal Code, which resulted in the shutdown of their website. While limitations on freedom of expression are outlined within Article 9.2 of the Charter, the state has overstepped this, rendering the restriction a violation to the right to freedom of expression, as the 4 2014 Canate versus Burkina Faso requirements are not satisfied. Regarding the first requirement, the shutdown of the website is not within the law. It is unclear whether this charge concerns the dissemination of non-consensual pornography or pornography in general. For a restriction to be in line, or rather for a restriction to be found within the law, it must first be sufficiently prescribed, and second, be in line with international norms, as required by this court in 2014 Canate versus Burkina Faso at paragraph 129. Notably, in the 2019 Pryanishnikov versus Russia, the European Court of Human Rights held at paragraph 32 that pornography in general is a protected form of freedom of expression. Moreover, within an African context of morality, Lillian Arts on page 17 of Poor Norms of South African Feminist Conversation about Pornography contends that pornography has become commonplace in many African states. Your Excellencies, even if the shutdown was aimed to address non-consensual pornography in particular, this shutdown is not prescribed within Article 112 of the Criminal Code and is therefore open to abuse. It is also not in line with international standards, as Article 3A of the Joint Declaration on Freedom of Expression and the Internet makes clear that shutting down an entire website is an extreme measure, analogous to the banning of an entire newspaper or broadcaster. Seeing as pornography is protected by Donamistan's morals and that this penalty of shutdown is not sufficiently prescribed, This restriction is not within the law. The second and third requirements are addressed together. That being that the measure taken by the state must be necessary to pursue the legitimate aim of protecting women's rights.
Vous avez parlé, oui, maître, vous avez parlé de la protection de la morale.
Yes,
je trouve que ceci est un peu vague. Expliquez-moi un peu plus sur cette protection de la morale. Parce qu'il s'agit, selon les faits, d'un objectif tout à fait légitime, et j'aimerais bien que vous expliquiez un peu mieux l'option de l'État en la matière. Qu'est-ce qu'il peut inclure dans la protection de la morale, même si vous vous opposez à cette protection de la morale?
Your Excellencies, it has generally been found that morality does not need to necessarily be sufficiently prescribed, although that would have been preferred in this instance, but the applicants accept that this is not the case. However, what is important within an African context, or an African construction rather, of morality, should allow for pornography and sex work, as it is recognized within the Maputo Protocol within Article 13D and 8, as this recognizes women's choice to free occupation as well as their personal development. And so pornography is in keeping with Dunamistan's morals. Your Excellencies, in continuing to address the second requirement and third of necessity, the least restrictive means that could have been taken by the state would have been for courts to order Bestanabad Aktu to pay a fine, as well as to take down and investigate specific non-consensual content. This would allow true retribution to the victims, as the users who upload this non-consensual content are held accountable, according to the 2018 UNESCO's Legal Standard on Freedom of Expression Toolkit for the Judiciary in Africa. This could also be used in tandem with verification and monitoring mechanisms, such as that imposed on the popular but safe site Reddit's Gone Wild, which is known for the dissemination of nude imagery, according to Nicholas Suzor on page 39 of Non-Consensual Pornography and Online Intermediaries. Seeing as these mechanisms would allow for the preservation of those whose livelihoods depend on the functioning of the website, and that the state has completely disregarded these successful alternatives, the shutdown is unnecessary. The last and fourth requirement concerns proportionality, which involves a harms versus benefits analysis. As before mentioned, Article 8 and 13D of the Maputo Protocol recognize women's choice to occupation as well as personal development. And so when the shutdown occurs, both workers and users' rights of the Maputo Protocol, as well as their fundamental right to freedom of expression, are violated. Moreover, the website allows for other functions, such as a dating platform, and so this shutdown affects a greater portion of content than is necessary. As has been demonstrated to this court, the harms of non-consensual pornography can be resolved by least restrictive means. And so this is a disproportionate violation to Article 9 of the Charter. Seeing as none of the Konate requirements are satisfied, the conviction of Bestanabad Aktu and the closure of its website is a violation to their right to freedom of expression. In the interest of time, I refer the court to page 2 of our memorials for further ventilation on arguments regarding defamation and terrorism. In addressing Prayer 3, Article 181 and Thimaka's conviction is a violation of Article 9 of the African Charter, as well as 19 of the ICCPR. This is elucidated in two arguments. First, that Article 181 is an unnecessary and disproportionate interference with the right to freedom of expression. And second, consequently, Thimaka's conviction is also unnecessary and disproportionate. I once again refer the court to the 2014 Konate requirements. Concerning necessity, paragraph 9 of the facts indicates that Article 181 criminalizes mere insult of the president, holding imprisonment as the sanction. This does not meet the threshold to criminalize speech, as it is not hate speech nor an incitement to violence, as required by this court in 2014 Konate versus Burkina Faso at paragraph 165. Notably, the facts of that case are analogous to this instance, as Burkina Faso criminalized insult to government officials, which the court found to be a violation of the right to freedom of expression. Moreover, imprisonment is never an appropriate sanction, according to the Human Rights Committee's 2011 General Observation number 34. The respondents on page 4 of their memorials aver that the president's reputation is linked to that of public interest and should be protected by Article 19.3 of the Charter, which allows for protection of reputation. However, this is flawed and must be rejected, as the respondents fail to acknowledge that the least restrictive means of civil action can alleviate any harms to the president's reputation, as well as any consequent harms to public interest, without frustrating the right to freedom of expression. And so civil action should replace criminal defamation, as per the Commission's 2010 resolution on repealing all criminal defamation laws in Africa. For its far-reaching and onerous nature, Article 181 is unnecessary. With regards to proportionality, the Commission makes clear in 2010 Good versus the Republic of Botswana at paragraph 198 that government officials must demonstrate a higher tolerance to criticism so as not to stifle public debate and impede government accountability and transparency. Because in contrast to this, Article 181 elevates the president's reputation above that of private citizens and perpetuates self-censorship. Article 181 is disproportionate and violates the right to freedom of expression. Finally, in turning the court's attention to Thimaka's conviction, the conviction against her is unnecessary, as Thimaka's call for the upliftment of the Douala people's human rights must be protected, as it is vital to public debate, as in the Commission's ruling in the 2003 Law Office of Ghazi Suleiman versus Sudan, where the applicant had similarly been arrested on several occasions for promoting human rights in Sudan. Moreover, where in the 2018 Umuhoza versus Rwanda, where the applicant had been accused of divisionism, this court held at paragraph 143 that even opinions and words which shock, disturb, and offend are all still protected under the right to freedom of expression. But most importantly, Your Excellencies, Thimaka's words. Yes, Your Excellency.
Can you please provide circumstances in which considerations such as context of the society concerned may actually be a legitimate consideration in our analysis of whether a restriction on freedom of expression is actually legitimate? Thank you. And if you could make reference to an authority in that respect as well. Thank you.
Certainly, Your Excellency. I refer the court then to the 2006 Applicant versus Turkey, heard by the European Court of Human Rights, where in that instance, the state was addressing a terrorist threat and the applicant had made remarks about religious divisions. The court had held, despite having that context considered, that the statements must still give rise to a current risk or imminent danger. Applying that standard then to this instant case, we can see that after Thimaka's words were published, that no action was taken by anyone at any point after these words were published, and that Thimaka, in fact, calls upon the Douala people to be subdued and to not react to the state's provocation. And so this conviction against her can certainly not stand in this instance. Your Excellencies, her words do not meet the threshold for hate speech housed in Article 22 of the ICCPR, as there is no advocacy of national, religious, or racial hatred, which constitutes an incitement to violence. the 2013 Rebuttal Plan of Action makes clear that for words to class as incitement, actual action must be taken against a targeted group. Seeing as this did not occur in the state of Denamistan, the conviction against the marker is unnecessary. Finally, in addressing proportionality, even if the marker's words were hate speech or incitement to violence, the sanction of imprisonment is disproportionate. Your Excellencies, the marker is a young, poor mother of an infant child, forming part of the minority group of the Doualas. And so Article 30 of the Rights and Welfare of the Child makes clear that non-custodial sentences must be first considered. Seeing as the psychological and physical harms of imprisonment on both the mother and child outweigh any benefit, this restriction is a disproportionate violation of the right to freedom of expression. In addressing reparations, we pray that this court, regarding Prayer 1, ordered Denamistan to implement adequate safeguards. Regarding Prayer 2, that Bastanabad Aktu be acquitted and its website reopened. In terms of Prayer 3, that Article 181 be replaced with civil action and that the marker be compensated $20,000. And lastly, regarding Prayer 4, that Denamistan be ordered to prosecute the minister similar to the judgment on reparations of Zongo versus Burkina Faso. In closing, we pray that this court find the relevant violations of the Charter and any other human rights instrument before it concerning all matters.
Thank you, Ms. Pile. Thank you for that.
Council, will talking about reparation, which I'm glad you have addressed, because the requirement of the court now is that you present before the court your application, your request for reparation, as well as your application on merit. I like that fact that you have taken cognizance of that. Now, I want to ask, will the release of Tiamaka amount in any way to a form of mitigation, considering your demand, your request for reparation in that regard? Thank you. Or is she off? Maybe the next speaker will take that up then. Thank you.
Yes, I think when Ms. Moses comes during her rebuttal, she would have to address that issue that you have raised, Honorable Justice. Thank you very much. I'll now invite the respondent team. Are you ready? That the first oralist has the floor.
Est-ce qu'on peut commencer?
Yes, please proceed, and you have 15 minutes.
Les effets des manches, aussi virulents soient-ils, n'ont jamais remplacé un argument, encore moins un argument de droit. Madame la Présidente, honorable juge de la Cour.
Excuse me, can you put on your video, please? We can't see you.
Vous nous entendez? Est-ce que vous nous entendez?
Yes, we can hear you, but we cannot see you. Would like to see you.
Justice King,
C'est pas assez la connexion. C'est un souci de connexion. Est-ce qu'on peut commencer?
I can see him. I can see Flora Soro. Yes.
Oh, okay, I've seen, okay.
He's a gentleman, so it's a him. Thank you.
Please proceed.
Les effets des manches, aussi virulents soient-ils, n'ont jamais remplacé un argument, encore moins un argument de droit. Madame la Présidente, honorable juge de la Cour africaine des droits de l'homme et des peuples, recevez salutations les plus révérencieuses. Bête Soro, Kweku et Goulet, nous sommes avocats représentant les intérêts de l'État du Donamistan dans l'affaire qui l'oppose à l'ONG Liberté 2.0 et la société Boustanabad Actu. Madame la Présidente, c'est pour éviter que l'Internet ne serve de plateforme pour troubler gravement notre public interne que l'État du Donamista a non seulement promulgué le Code des communications électroniques, dont l'article 8 protège le droit à la vie privée des individus, mais également pris ses responsabilités en condamnant la société Boustanabad Actu et Tiemaka pour avoir grossièrement abusé de leur droit à la liberté d'expression. Quant au ministre de l'Éducation nationale, du Donamistan, il n'a pas fait l'objet de poursuites tout simplement parce que les faits de corruption ne sont pas avérés. Allez-vous donc faire droit à de telles allégations qui ne visent aucun autre but que d'entacher la réputation d'un État qui s'est maintes fois illustré dans la protection des droits de l'homme?
Excuse us, Counsel. What is your structure? Are you addressing jurisdiction or you are going straight to merit? Can you give us a rundown of your structure like the applicants did? And I also observe you raised some preliminary objection regarding jurisdiction and admissibility. I would think it's best for you to address those issues before you go to the merits of the case or of the application. Thank you.
Honorable juge, nous, bien sûr, allons étudier la compétence et la recevabilité de la requête. Et nos confrères, Maître Soro et Maître Kwaku, se chargeront du fond. Madame la Présidente, honorable juge, l'État du Donamista aurait bien voulu amorcer le débat au fond. Toutefois, l'existence d'irrégularités procédurales intolérables le rend superflu. L'article 49, alinéa 1er, du règlement intérieur de votre juridiction vous impose de procéder in limine litis à l'examen de la compétence de votre cour et la recevabilité de la requête. Nous établirons que votre cour n'a pas compétence pour connaître de cette affaire et que la requête de la partie adverse est irrecevable. Distingué juge, la compétence de votre cour s'analyse sous 4 aspects: les compétences personnelles, temporelles, matérielles et territoriales. Ces 4 aspects de la compétence étant cumulatifs, dès lors que l'un de ces aspects fait défaut, votre cour doit impérativement conclure à son incompétence. C'est à juste titre que nous démontrerons que votre cour n'a pas compétence personnelle et temporelle pour connaître de cette affaire. Madame la Présidente, l'article 5 du protocole relatif à la Charte africaine des droits de l'homme et des peuples portant création d'une Cour africaine des droits de l'homme et des peuples énumère les entités habilitées à accéder au prétoire de votre juridiction. Toutefois, il ne ressort d'aucun paragraphe de cette disposition que les sociétés commerciales sont des entités ayant qualité pour agir devant votre cour. Et à cet égard, vous avez affirmé avec éloquence, dans la demande d'avis consultatif introduite par le Comité africain d'experts des droits et du bien-être de l'enfant au sujet de son statut juridique, paragraphe 98, ce qui suit. Nous citons. En effet, un principe de droit bien connu prescrit que lorsqu'une liste exhaustive est fournie dans un traité, elle ne peut pas être interprétée pour y insérer une entité qui n'y est pas mentionnée. Fin de citation. Une telle position de votre cour a été réaffirmée dans l'affaire Jean-Claude Gombert contre l'État de Côte d'Ivoire, que la partie adverse a mal interprété. Et dans cette affaire, votre cour a affirmé, nous citons, la Cour de séance considère qu'en tant que juridiction des droits de l'homme et des peuples, elle ne peut en principe connaître que des violations des droits des individus, des groupes d'individus ou des peuples sur saisine des entités ou personnes mentionnées à l'article 5 du protocole, mais pas des droits des autres personnes morales, de droit privé ou de droit public. Fin de citation. Madame la Présidente, honorable juge, interprétation cessat in claris. L'interprétation cesse lorsque la loi est claire. Boustanabad Actu est une société commerciale, donc une personne morale, se prévaut d'une qualité qui n'est pas sienne. Votre cour conclura à son incompétence personnelle à l'égard de la société Boustanabad Actu. Et quand bien même, l'ONG Liberty 2.0 semble avoir compétence personnelle pour saisir votre cours, une telle compétence ne saurait résister à l'incompétence temporelle de votre cours et l'irrecevabilité de la requête. Selon les dispositions de l'article 28 de la Convention de Vienne sur le droit des traités, adoptée le 21 mai 1969 et entrée en vigueur le 27 janvier 1980, nous citons, à moins qu'une intention différente ne ressorte du traité ou ne soit par ailleurs établie, les dispositions d'un traité ne lient pas une partie en ce qui concerne un acte ou fait antérieur à la date d'entrée en vigueur de ce traité au regard de cette partie ou une situation qui avait cessé d'exister à cette date. Fin de citation. Madame la Présidente, ainsi dans la détermination de sa compétence temporelle, votre cours tient compte des dates d'entrée en vigueur à l'égard de l'État défendeur, des instruments internationaux de protection des droits de l'homme, du protocole de Ouagadougou et la date de la déclaration facultative prévue à l'article 34.6. Ainsi qu'il ressort de l'affaire Joseph Peter Chacha contre l'État de Tanzanie, toutes les dates à considérer sont cumulatives et toute prétendue violation doit être postérieure à celle-ci. Dans les faits, le Code des communications électroniques auquel se rattache l'article 8 litigieux a été promulgué le 12 décembre 2017. À l'inverse, la déclaration facultative prévue à l'article 34.6 a été effectuée le 12 avril 2018, donc postérieurement à la prétendue violation. L'argument tiré de la violation continue ne saurait prospérer dans la mesure où la promulgation du code est un fait ponctuel dans le temps. En conséquence, honorable juge, la compétence temporelle de votre cours n'est pas établie. Et à supposer que vous admettiez la compétence de votre juridiction, la requête de la partie adverse ne saurait franchir les aires de la recevabilité. Selon les dispositions de l'article 56 de la Charte africaine des droits de l'homme et des peuples, les requêtes doivent être introduites postérieurement à l'épuisement des voies de recours internes et dans un délai raisonnable. Singulièrement, l'article 56.6, il impose, point 5, il impose au requérant de saisir votre cours postérieurement à l'épuisement des voies de recours internes si elles existent, à moins qu'il ne soit manifeste.
Counsel, can you address the bench on whether the violation was a continuous one? Are you suggesting that it's an instantaneous violation when you have the law still in place?
Distingué juge, la réponse à votre question nous emmènera à définir ce qui est d'abord une violation continue et une violation instantanée. La théorie des violations continues a été développée par la Cour africaine des droits de l'homme et des peuples dans l'affaire Norbert-Zongo contre l'État du Burkina. Et elle a défini la violation continue comme une violation qui a commencé avant l'entrée en vigueur d'un instrument international de protection des droits de l'homme et qui a continué postérieurement à la dite entrée en vigueur, contrairement à la violation instantanée qui a commencé avant l'entrée en vigueur d'un instrument, mais dont les effets perdurent postérieurement à l'entrée en vigueur du dit instrument. Et dans les faits, distingués juges, il s'agit de violations instantanées, si on peut le dire ainsi. Mais en tout état de cause, distingués juges, il n'y a pas de violation dans la présente espèce. S'agissant du premier grief relatif à l'article 8 du Code des communications électroniques, cette disposition ne peut être détachée du Code des communications. Or, un tel code a été promulgué le 12 décembre 2017 et la déclaration qui donne compétence à votre cours de connaître des requêtes individuelles a été effectuée le 12 avril 2018, donc postérieurement à la supposée violation. Votre cours ne peut donc connaître de cette affaire pour une compétence temporelle en raison de violations instantanées. Et de plus, selon les dispositions de l'article 56, alinéa C de la Charte africaine des droits de l'homme et des peuples, les requêtes doivent être introduites postérieurement à l'épuisement des voies de recours internes si elles existent, à moins qu'il ne soit manifeste à votre cours que la procédure des recours se prolonge de manière anormale. Il en résulte que la règle de l'épuisement des voies de recours internes revêt un caractère fondamental dans la recevabilité de la requête. C'est pourquoi, dans les affaires présentées contre le Rwanda et puis contre le Mali,
Mr. Go, don't you think the remedies pursued, the remedies domestically was unreasonably long, took unreasonably long time, and therefore it was not effective, it was not available, it was not an efficient remedy? Especially the one relating to the Minister of Education.
Distingué juge, dans l'affaire Wilfred Oyango contre l'État de Tanzanie, votre cour a défini ce que c'est qu'un délai raisonnable. Nous allons d'ailleurs citer l'affaire Wilfred Oyango. Votre cour a affirmé, lorsque des raisons peuvent justifier la prolongation de la procédure dans une affaire, il n'y a pas lieu de parler de prolongation de manière anormale. Fin de citation. Or, dans les faits distingués juge, s'agissant du ministre de l'Éducation nationale, le délai n'est pas déraisonnable puisque la gravité des accusations et la qualité de ministre nécessitent une analyse minutieuse des faits. L'ONG Liberty 2.0 n'a donc pas épuisé les voies de recours internes. De plus, la règle de l'épuisement des voies de recours internes peut être écartée lorsque la voie de recours est inefficace, ainsi qu'il ressort de l'affaire Daouda Diawara contre l'État de la Gambie. Dans les faits, la société Boustanabat d'Actu n'a pas saisi la Cour suprême, arguant que cette dernière serait liée par les décisions de la Cour constitutionnelle. Pourtant, honorable juge, vous avez affirmé avec éloquence, dans l'affaire Mariam Kouma et Ousmane Diabaté contre l'État de Mali, qu'une simple appréhension ne saurait libérer un requérant de son obligation d'épuiser les voies de recours internes. À tout le moins, pour qu'une appréhension soit acceptée par votre cour, le requérant doit en apporter la preuve, ce que ne fait pas à l'évidence la société Boustanabat Actu. Ainsi, les voies de recours relatives aux deux griefs précédemment analysés n'ont pas été épuisées par les requérants. Au surplus, votre cour a été...
Counsel, if I may come in here, can you please explain what is the time of the action which is alleged to constitute a violation? When did it happen? I think the timing of the action needs to be clarified rather than the time when the law in question was adopted. So there is an action taken by the government on the basis of a law. So when did the action happen? That is a crucial issue here.
Distingué juge, la promulgation du code électronique a eu lieu le 12 décembre 2017. Et au contraire, la déclaration facultative de reconnaissance de la compétence de recours a été effectuée le 12 avril 2018, donc postérieurement à la supposée violation tirée du Code des communications électroniques. Il s'agit donc d'une violation instantanée, dans la mesure où la promulgation du Code électronique est un fait qui ne s'étend pas dans le temps, mais est un fait instantané et précis. Au surplus, distingué juge, votre cour a été saisie.
But the contestation is not about the date of promulgation. The contestation is about the action taken on the basis of that law. And I'm asking, when did the government take action on the basis of that law? The action which led to this case.
Distingué juge, les actes du gouvernement relatifs à cette loi peuvent être assimilés à des effets de violation. Il ne s'agit pas d'une violation stricto sensu, au sens strict, mais des effets qui se poursuivent, des effets qui découlent de la promulgation du code électronique. Puisque, concernant le paragraphe 15 du rapport factuel, c'est le code des communications électroniques et en son article 8 qui sont visés. Les actes du gouvernement sont assimilés pour nous, distingués juges, à des effets de violation, donc à des violations instantanées. Au surplus, votre cours a été saisi dans un délai déraisonnable. L'article 56, alinéa 6 de la Charte africaine des droits de l'homme et des peuples impose à votre juridiction que les requérants introduisent les requêtes dans un délai raisonnable.
Thank you, Mr. Gold. Your time is up. Your time is up, Mr. Gold. Your time is up. Thank you very much. We'll now move on to the next oralist. Counsel, can you take the floor, please? Thank you.
Thank you, Presiding Judge. I am Kweku Ejapong, and in the next 15 minutes, I shall address this court on the first substantive issue and the second substantive issue. The first substantive issue concerns the legality of Article 8 of the ECC, and the second pertains to the legality of the act of convicting and closing mustalabadact2action.com. However, before I proceed to address these substantive issues, the court ought to take note of one thing: that the state of Donamistan is the last individual to even think of violating the rights of persons. However, it has become necessary to do this with the aim of protecting lives and livelihoods. With this at the background, let us proceed to deal with the issues. Your Excellencies, the Presiding Judge, the first substantive issue pertains the legality of Article 8 of the ECC. On this, it is our claim and our case that Article 8 of the ECC is in line with international law. In order to substantiate this assertion, I shall furnish this court with arguments on two thematic areas. The first is the non-execution of warrants, and the second, the test of strict necessity. Your Excellencies, the applicant stated, both in their memorials and their oral submissions, that there were no checks to the Minister of Communications' power to intercept the communications of Donam citizens. However, such an assertion arises from a mere surface reading of the facts. Your Excellencies, the court ought to take note of something: that there is a difference between the issuance of a warrant and the execution of a warrant. The act of interfering into the communications of persons is the execution or implementation of the warrant and not the issuance of the warrant. Your Excellencies, in paragraph 4 of the hypothetical facts, it is stated that once the Minister of Communications issued the warrants, he had the responsibility of informing the chair of the Data Protection Commission, whose responsibility it was to ensure that the warrants complied with international and municipal law. Your Excellencies, paragraph 2 of the facts further enunciates that Donamistan is a monist state, which means that all the international law as ratified by the state of Donamistan constitutes a corpus juris of the municipality. In this instance, it was the duty of the chair of the data protection to ensure that the issuance of the warrants and the conditions under which the warrants were issued fell within the ambit of municipal and international law before the warrants was executed by law enforcement agencies. On this, it is clear that what the applicants were looking for, to wait a system that checked the power of the communications minister, was available. The law provided in Article 9 of the ECC and Article 33 a self-repairing mechanism to ensure that the rights of Donam citizens are not unduly harmed. Proceeding to address this court on the second leg of the first issue, which pertains to the test of strict necessity, it is our case that this test has been satisfied by the state of Jonamistan. Indeed, the Budapest Convention on Article 20 and 21 allows for the states to intercept the private and secure communications of persons when absolutely necessary and when pursuant to a legislation. This means there are two requirements that must be satisfied. The first is that the interception must be pursuant to a legislation, and the second is that it must be necessary. Concerning the first element, to wit, that it must be pursuant to a legislation, Your Excellencies, paragraph 4 reminds us that the state of Jonamistan enacted the Electronic Communications Code before, which gave power to the Minister of Communications to intercept the secure communications of Jonam citizens. This power was not subject to the minister's whims and caprices, but was conferred upon him by a written, stated, promulgated, and enacted law by the legislature of the state of Jonamistan. Your Excellencies, the second element concerns whether or not the act of interception is absolutely necessary, and on this is the main contention as stated by the applicants. Your Excellencies, you decided in the case of Tanganyika Law Society versus Tanzania on paragraph 106 and 106.1 that necessity can be defined with three cumulative elements. The first is that the interference must arise out of a social need. The second is that it must result in a legitimate aim. And the third is that the extent of intrusion should be proportionate to the legitimate aim sought. And that was the main contention from Counsel Mazanga, or Advocate Masanga on the other side. Your Excellencies, concerning the first issue, which is the social need that necessitates the interception, the facts evince a clear situation. The sub-region of Jonamistan has been scarred with instability, marinated with violence, seasoned with division, and grilled and flavored with the threat of harm. Your Excellencies, Jonamistan is in a state of alarm. There is a terrorist group on the loose, and there is also threat of secession. The government of Jonamistan remembers secessionism in Africa and what it causes. It remembers Congo and Katanga. It remembers Nigeria and Biafra. It remembers South Sudan and Sudan. It remembers Ethiopia and Eritrea. Therefore, out of this social need of protecting the lives and livelihoods of citizens of Jonamistan, yes,
I may, are you suggesting that cessation of and on itself is a threat to peace and security?
Pardon, can you come again, please?
Cessation,
yes,
of and on itself is a problem on its own. Is there any authority in international law that says that cessation is a problem?
Your Excellencies, secessionism in and of itself is not a problem inherently. However, there is a plethora of examples that indicates the pain, suffering, hunger, starvation, and death that accompanies secessionism. For instance, in Biafra, the Biafra conflict, which arose out of the threat of secession of the Biafra region in Nigeria, led to the death of 1.2 million people, according to some sources. Therefore, it is out of these instances that the government of Jonamistan attempted to keep the state together. This is not just so.
So are you suggesting that it's better for a subnational group to endure inhuman conditions of subjugation, and perhaps that subjugation leading to violence. And if I may put to you, in South Sudan, it led to the perishing of over 2 million people. So is that what you are saying should happen there?
No, Your Excellencies, but international law states or evinces that before secessionist states must be granted credence, it must arise out of a need of avowed human rights violations, particularly when targeted to a certain group. Your Excellencies, Diola activists have not been able to prove any vile human rights violations on the part of the non-Amistan government. There are no genocides against Diolas. There are no mass killings against Diolas. And therefore, we humbly pray the court to side with the principle of uti possidetis as formulated after the independence of certain Southern American states from Spain to ensure that the state of Donamistan is kept together. After all, if at any instance, groups of people want to succeed just because they feel like secession for them is important, then Africa will not be one. Indeed, many countries in Africa are currently battling with a problem, but that does not mean that states should go around dividing themselves based on...
Can you provide an authority from the jurisprudence of either the African Commission or the African Court on what you are explaining now?
Your Excellency, I'll be happy if you could expatiate further.
So you are providing us saying that there has to be a systematic violation of human rights in order to justify legitimately secessionism. And I'm asking, where is the authority for that assertion? So if you have any authority from the jurisprudence of the African human rights.
Within the African courts?
No, it can be from the African Commission as well.
Well, Your Excellency, we can take note of the Katanga dispute, where the African courts stated that there must be, to legitimize the secession of Katanga from Congo, there must be systematic violations against the persons or the group in that region, Your Excellencies. And this was also further enunciated by the European Court in the Kosovo crisis, where upon the dissolution of Yugoslavia, the court held that such calls for secessionism was legitimate because ethnic persons from Bosnia and Herzegovina had their rights being systematically violated against. Therefore, the jurisprudence exists in Europe and has been done in the instance of Africa.
Mr. Counsel, can you also address this issue for me in terms of the state has a balancing interest to do? Don't you think it should have pursued less restrictive measures to secure its interest, less restrictive measures, because the measures introduced, there were not sufficient safeguards. The measures introduced invaded the right to privacy, the right to freedom of expression, etc., etc. Thank you.
Your Excellencies, in the case of Class versus Germany, on paragraph 53 of the judgment, the European Court on Human and People's Rights held that independent bodies may well check executive power regarding the interception of communications. Your Excellency, in this instance, the independent body is the Data Protection Commission, which was charged, according to Article 9 and Article 33 of the ECC, with vetting the legality of the Minister of Communications' issuance of warrants. But even putting that aside, assuming there were no adequate safeguards, there are, as I have already stated and referred you to the case of Class versus Germany, but assuming there were no adequate safeguards, Your Excellencies, we must note the social need that necessitates such an action. Before 9/11, the checks at airports were not so intrusive to the person. But today, if we were coming to Senegal, we would have been made to remove our shoes and our bags at airports and things of the sort. This arose out of a need to protect the lives and livelihoods of citizens. Therefore, as is evinced in Article 9 and 33 of the ECC, class versus Germany, and the social need, then it is clear that such an act of interference is most definitely necessary to protect the rights, to protect the lives and livelihoods of Donam citizens, particularly when there is a terrorist group on the loose and there is threat of violent secessionism. Proceeding to address this court on the second substantive issue, it is our case that the closure and conviction of bustanabad-action.com does not violate international law. To further advance this claim, I shall furnish the court with argument on two thematic areas. The first is the respect for human dignity, and the second is the argument pertaining to morality. Concerning the respect for human dignity, it is our case that in order to preserve and protect the charter, the Donam government closed down the pornographic site to preserve the dignity of our Donam mothers.
Your time is up.
Yes, Your Excellencies. Your Excellency, thank you very much for your time, but it is our case that the closure of the site was necessary to preserve the human dignity of these subjects that were humiliated by the selfish interests of the owners of Bustanabad Actu, as well as preserving the morality of the state.
Thank you very much. Thank you, Mr. Achibong. Do we have Mr. Soro available? Mr. Soro, counsel, you have, oh, Ms. Soro, counsel, you have the floor.
Vous m'entendez?
Oui. Oui. Yes.
Madame la Présidente, honorables membres de la Cour africaine des droits de l'homme et des peuples, recevez nos salutations les plus distinguées. Nous sommes Maître Soro Flora, comme l'ont précédemment annoncé Maître Goulet et Maître Cocody, et nous représentons les intérêts de l'État du Donamistan dans le litige qui l'oppose à l'ONG Liberty 2.0 et à la société Bustanabad Actu. Si la démocratie promeut l'idée de liberté, celle-ci ne signifie pas l'impunité. Dans le déroulé de notre argumentation, vous constaterez avec nous, honorables membres de la Cour, que les violations, les prétendues violations aux droits de Tiemaka ou encore le grief relatif à la corruption lié au ministre de l'Éducation ne relève que d'une pure fabrication des faits. L'État du Donamistan est, comme tout État, respectueux des droits de l'homme, conscient de l'importance du droit à la liberté d'expression pour l'épanouissement des individus en société. Cependant, ce droit doit s'exercer conformément à l'alinéa 2 de l'article 9 de la Charte africaine des droits de l'homme et des peuples dans le cadre des lois et des règlements. Si Tiemaka a fait l'objet d'une condamnation, c'est bien parce que cette dernière a outrepassé son droit à la liberté d'expression quand elle a transgressé l'article 181 du Code pénal du Donamistan, article pourtant prévisible, légitime et nécessaire dans une société démocratique, ainsi que vous le préconisez dans l'affaire Ingabire-Victoire contre Rwanda du 24 novembre 2017. En effet, dans cette affaire, vous avez affirmé que le critère de prévisibilité suggérait, outre l'existence d'une loi en droit interne, sa clarté et sa précision. En l'espèce, l'article 181 est manifestement prévisible dans la mesure où il permet à chaque individu d'y adapter ses agissements. En effet, il définit clairement les comportements proscrits, les moyens pour les atteindre et même la nature des infractions qui en découlent. Partant, Tiemaka était clairement avertie de ce à quoi elle s'exposait en invectivant et en calomniant le président de la République. De même que cet article est prévisible, il est également légitime. S'agissant de la légitimité de l'article 181, il ressort du paragraphe 3 de l'article 19 du Pacte international relatif aux droits civils et politiques que la protection de la réputation d'autrui constitue un but légitime. Dans la présente affaire, il est indéniable que le but attaché à l'article 181 est la protection du président de la République. Il s'ensuit qu'il s'agit là d'un but parfaitement légitime qui ne...
Maître, si je peux me permettre, je vous interromps. En quoi la personne du président de la République devrait bénéficier d'une protection accrue, selon vous, face à des propos jugés diffamatoires ou excessifs?
Honorable juge, la fonction du président de la République ne bénéficie, ce n'est pas parce que les propos ont visé le président de la République que Tiemaka a été condamné. Il s'agit bien de l'analyse de la teneur des propos contenus Tiemaka. En effet, Tiemaka a dans son discours incité à la haine les populations du Donamistan quand elle a affirmé que le président de la République était un voleur qu'il fallait renverser. De tels propos excèdent le champ d'exercice du droit à la liberté d'expression, en ce sens que la liberté d'expression n'admet que des critiques. Et les propos contenus Tiemaka ne rejoignant rien des critiques, ils s'assimilent plutôt à des insultes et à des outrages. Ainsi, de tels agissements doivent être légitimement condamnés dans un État.
Si je peux me permettre, justement, il s'agit des critiques, une critique très forte, mais tous les jours, dans tous les pays du monde, on mentionne que les présidents ou les ministres sont des voleurs, et pour autant, ces principes ou ces affirmations ne poussent pas à la haine. Donc, pouvez-vous faire le lien entre de tels propos et soi-disant la haine qu'ils auraient générée?
Honorable juge, dans l'affaire Ngabire Victoire contre Rwanda, vous avez affirmé que lorsque l'on analyse la nécessité de la restriction dans les États, il faut tenir compte des circonstances de l'espèce. En l'espèce au Donamistan, la menace terroriste plane sur cet État. Également, relativement au paragraphe 7 du rapport factuel, les conflits interethniques entre les Djoula et les personnes d'ethnie Bondo au Donamistan, il y a toujours des velléités relatives à l'ethnie. Ainsi, quand Tiemaka appelle la population à renverser le président de la République en affirmant que ce dernier est contre les personnes d'ethnie Djoula, ceci peut mettre en péril la sécurité de cet État. C'est donc pour cette raison que cette dernière a été condamnée et que cette condamnation est légitime. De plus, honorable juge, si les insultes et les outrages étaient un discours qui pouvait être admis devant votre cour ou dans les États, vous n'auriez pas préconisé comme condition de recevabilité des requêtes que ces dernières ne contiennent pas des discours outrageants et insultants.
Si je peux me permettre, maître, ce n'est pas nous qui avons intégré dans la charte de telles conditions de recevabilité, mais ce sont les auteurs de la charte.
Honorable juge, il est certes vrai que ce n'est pas vous, cependant vous appliquez ces principes. Ceci étant, vous adhérez bien à ce que la charte dit. Donc, relativement à tout ce qui précède, nous affirmons, et vous conviendrez avec nous, que la condamnation de Tiemaka était une mesure nécessaire dans une société démocratique. De plus, relativement à la proportionnalité de la nécessité, il ressort de l'affaire Radio France et Haute contre France qu'on ne saurait considérer en matière de diffamation une réponse pénale comme disproportionnée au but légitime poursuivi. En l'espèce, alors qu'elle exhiba ses propos sur la toile, Tiemaka ne fut condamnée qu'à une seule année d'emprisonnement. Pourtant, le mode de diffusion qu'elle a choisi permet une retransmission à grande échelle de l'information. Il va sans dire que cette dernière a certainement réussi à nourrir dans l'esprit d'une multitude des stigmates à l'effet de déprécier le président de la République et de susciter des révoltes contre l'organe étatique. Partant, la condamnation de cette dernière est légitime car au regard de la portée de son acte, celle-ci aurait pu être astreinte à une peine d'emprisonnement plus sévère que celle à laquelle elle a été soumise au donamistan.
Maître, je me permets à nouveau de vous interrompre. Il y a quand même un mouvement international contre la pénalisation de la diffamation. Et une seule année, c'est déjà une année de trop. Que répondez-vous à cet argument?
Honorable juge, certainement, ce mouvement a été institué dans le but que les États n'excèdent pas de manière arbitraire leurs prérogatives en limitant le droit à la liberté d'expression des individus. Cependant, dans les cas où les individus tiennent des discours haineux, appelant à la violence, à la discrimination, l'emprisonnement pouvait être requis. Et ceci a clairement été défini au paragraphe 165 de l'affaire Loïsa-Konaté de la Cour africaine. De plus, selon la Cour européenne, l'emprisonnement pour diffamation devrait être une mesure en dernier ressort, ce qui implique que ceci n'est pas totalement exclu. Cependant, quand les circonstances de l'espèce l'exigent, l'on pouvait avoir recours à l'emprisonnement. Ainsi, vous retrouverez tout ceci au paragraphe 158 de l'affaire Loïsa-Konaté précitée. Ainsi, la condamnation de Timaka est légitime. De même, nous vous démontrerons, dans la suite de notre argumentation, que les faits du ministre de l'Éducation ne peuvent être assimilés à la corruption. Il ressort de l'article 4, alinéa C, de la Convention de l'Union africaine sur la prévention et la lutte contre la corruption, que la corruption s'entend, et nous citons, de l'accomplissement ou l'omission par un agent public ou toute autre personne d'un acte dans l'exercice de ses fonctions au fin d'obtenir des avantages illicites pour lui-même ou pour un tiers. Fin de citation. Il est cher de souligner, au regard de cette disposition, que la corruption est une faveur rendue en contrepartie d'un avantage qu'une personne rend à une autre dans l'exercice de ses fonctions. Dans les faits, le paragraphe 12 du rapport factuel nous donne de constater que lors d'une enquête...
Sorry to interject. So what if the attitude or the action by the minister is not a corrupt practice? What then will you term it?
Honorable juge, les actes du ministre ne sont pas de la corruption en ce sens que dans cette affaire, seul le directeur de l'unité de lutte contre la cybercriminalité entendait obtenir des avantages dans l'exercice de ses fonctions. Donc, étant donné les définitions liées à la corruption et que est contenu dans la Convention de l'Union africaine sur la prévention et la lutte contre la corruption, au regard de ces dispositions ou de ces définitions, nous ne pouvons aboutir à la conséquence selon laquelle le ministre de l'Éducation est coupable de corruption. Le ministre de l'Éducation n'est coupable d'aucun fait, car dans cette affaire, seul le directeur entendait obtenir des avantages pour lui-même. Et ceci se laisse entrevoir clairement au paragraphe 12 du rapport factuel. Au regard, eu égard...
Sorry to interject again. The fact that the crime, or well, in quotes, committed by the minister was no longer exposed, at whose peril is that?
Honorable juge, nous n'avons pas compris votre question.
Yes, the director was compromised, but I am saying there's another consequence arising from that compromise, which affects the generality of the people. Is it not a possibility?
Honorable juge, dans la présente affaire, ce que nous essayons de vous expliquer, c'est que peut-être relativement au rapport factuel, il y a certainement eu une offre. Cependant, l'offre du ministre de l'Éducation n'est pas celle qui a entraîné l'action du directeur de l'unité de lutte contre la cybercriminalité, en ce sens que ce dernier avait déjà pris la décision de ne pas porter les informations liées au ministre à la connaissance du président de la République. Et ceci se laisse entrevoir quand il s'est accaparé. Il a pris la décision de s'accaparer les informations relatives au ministre. En s'accaparant toutes les informations liées au ministre de l'Éducation, il avait à cet instant mis en exergue le fait qu'il n'avait point l'intention de porter les dites informations à la connaissance du président de la République. Ainsi, il n'y a pas de lien de causalité entre l'action du ministre et celle du directeur de l'unité de lutte. On ne peut donc parler de corruption. Au regard donc, de l'ensemble des considérations qui précèdent, vous l'aurez certainement remarqué, l'État du Donamistan n'a violé aucun droit de l'homme en instituant l'article 8 du Code des communications électroniques, encore moins en condamnant la société Boustana-Badactu et Thiemaka pour leurs excès respectifs. De plus, en s'abstenant de poursuivre le ministre de l'Éducation, ce dernier a agi conformément aux standards internationaux en la matière. Plaise à la Cour, déclarer la requête de la partie adverse irrecevable, la débouter de son action et surtout rétablir l'État du Donamistan en son honneur. Ainsi sera justice. Nous avons plaidé.
Thank you very much, Ms. Soro, for that. I will now give the floor to Counsel Moses. She has a 3-minute rebuttal. Counsel Moses, are you there?
Yes, Your Excellency.
Thank you.
Judge President, Your Excellencies, the applicant...
Counsel Moses, before you take the floor, you would recall that Justice Anukan had raised some issues. Do you have that issue that she raised that you need to respond to?
Yes, Your Excellency.
Okay,
Justice
well.
Anukan.
Thank you.
Your Excellencies, the applicant has 4 points of rebuttal and will deal with Ms. Justice Anukam's question after the points of rebuttal. First, in relation to admissibility, we have heard from the respondents that Bastanabat Act 2's claims before the court are inadmissible, as Bastanabat Act 2 has apparently failed to exhaust local remedies. We submit that this argument is flawed and should be rejected, as according to paragraph 11 of the facts, Bastanabat Act 2 pursued the question of constitutionality all the way to the Constitutional Court, which is the apex court of Donamistan, according to paragraph 2 of the facts. And consequently, it is clear that local remedies have been exhausted. Second, in relation to prayer 1, we have heard from the respondents that seeing as the state is a monist state, that they have enacted the appropriate safeguards. We submit that this argument is flawed and should be rejected, as simply being a monist state does not guarantee that Donamistan will implement the appropriate safeguards. And to give the court a specific example, Donamistan has failed to implement the safeguards regarding the details of the filtration system being publicly accessible, as well as the details regarding the storage and destruction of data. Third, in relation to prayer 2, we have heard no submissions from the respondent, and thus a call on the court to take this as a concession. Fourth, in relation to prayer 4, we have heard from the respondents that the minister's act of corruption is not indeed an act of corruption. We submit that this argument is flawed and should be rejected, as Article 4 of the AU Anti-Corruption Convention clearly stipulates the acts of corruption, and it is clear that the minister's act of corruption is indeed an act of corruption, and the respondents have also failed to make any submissions on Donamistan's failure to prosecute the minister. Now, in turning the court's attention to Justice Anukam's question, we submit that on reparations regarding the $20,000, we are appealing to the court that Thiamaka should be paid these $20,000 in compensation for the moral justice that she has suffered, and not that the court should initiate retrospective judgments. In conclusion, we submit that the court should not find any persuasion within the respondent's arguments and find all the relevant violations. I'll now take my leave of the court, seeing that my time has elapsed.
Thank you very much, Ms. Moses. I don't know, Justice Anukram, are you okay about your question you asked?
Yes, Madam President, I'm okay with it. Thank you.
Thank you. Well, we have now come to the end of Council's submission, and we will take a stand down for deliberations. I will hand over to the moderator so that we as members of the bench can take a stand down for deliberations. Over to you.
Thank you, Madam President. We're going to put the applicants, the counsels in the different groups into the waiting room while the judges deliberate. If you could give me 1 or 2 minutes to quickly do that, then the judges can proceed to deliberations. Quickly, Respondent. Okay, we